Good afternoon and welcome back to In the Office with Scott and Wallace. I'm Robert Scott.
Clint Wallace, happy Tuesday.
Matt McNamara, happy Tuesday.
And so you got all three of us today. We're excited to be with you. Today we're going to talk about a couple different topics. We're going to hit on something germane to personal injury law, which of course Clint and I handle, and then we're going to flip it to Matt and let him talk about equal pay day, April 2nd. I'm sure that people on social media have seen that trending, and so we're going to allow you to talk a little bit about that. But Clint, I wanted to talk today about damages.
Okay.
We've talked a lot about liability and how liability may attach in a car accident, for example, or other types of cases during these segments, but we haven't talked a whole lot about damages.
Okay.
And it's a critical component, as you know, to any cause of action, but specifically a negligent cause of action. And what am I talking about when I talk about damages?
Okay, so good question. Common types of damages we see when somebody's been injured as a result of someone else's negligence. The first is loss of wages, both past and future. So if you've lost wages in the past, or if doctors think that because of your injuries you're not going to be able to work in the future, those are damages that you sustain that impacts your family, if you're bringing home money, things like that. All right, so that's the first part of it. The second part is medical bills, both past and future for that as well. Medical bills that you've incurred after the accident, but before the case is resolved, and sometimes people are injured and their doctors think they're going to need future medical care. So we want to make sure there's money there to pay for that in the event that you're going to have that care in the future. So that's
Those are economic
damages.
Yeah.
So non-economic damages, why don't you tell what unlocks the key to that in Florida?
Well, with car accident claims, because they're governed by our no-fault statute, initially they offered, the no-fault statute offers limited tort immunity to the at-fault driver or the at-fault driver's insurance company. Pursuant to that statute, the injured plaintiff has to prove that he or she suffered a permanent injury, and that is the key to unlocking the door to entitlement to pain and suffering damages. You have to make a prima facie case, which just means that you have either by the nature of the injury, like if you lost a leg in a car accident or something, God forbid, then that would obviously be a permanent injury. If you have a scar, then that's a permanent injury. Most of the time, in most cases, the injuries are internal. You can't necessarily see how they may be permanent. And so what we do is we rely on a medical professional to offer an expert opinion about whether or not the injury is permanent. And once that testimony is before a jury, then that's prima facie evidence, and then the jury can consider that testimony and make a determination about whether or not pain and suffering damages are warranted.
Okay.
Personally, I don't like the law at all because it's a legal fiction. Just based on what I just said, like how many times do we have a client come into the office immediately after the car accident in excruciating pain?
Yeah, right.
Well, the law doesn't even acknowledge that pain.
Sure.
Not until we have that testimony are we allowed to present or ask the jury to award pain and suffering damages. So it's one of the problems with the law, and we've hit on that before.
And it's unique to Florida because we also practice in Georgia, and the law is not the same in Georgia.
Exactly. And so, as we've talked about, mandatory bodily injury coverage, and was it last segment or segment before, that's on the agenda. I think it was being discussed this week over at the legislature. So we don't know. I don't know if it'll get any traction this year, but it is something that we're monitoring and we think would be a good idea as far as one of the only states in the union without it. So we'll see what happens. But one of the things that does come up before I get to Matt about damages is a lot of times when we're discussing like settlement offers with our clients or something like that, one of the things on their mind is, well, I got hit by a drunk driver, for example, and it could have killed me, or it could have killed a member of my family. Like, shouldn't I be compensated for that? And what's the answer to that?
Yeah, so the law doesn't recognize damages that could have happened. It's not, this could have killed me, this could have injured me worse. That's not a recognizable damage. It's what did happen and what we can prove through the evidence that matters. But a second element to your question, a type of damage that we didn't talk about is punitive damages. And if somebody's conduct, normally damages are there to put you back in the position you would have been in before, they're not to penalize the other party. Punitive damages are situations where somebody's conduct is so egregious that the law says not only do we want to put you back in the position, you, the injured person, where you would have been before the accident, we want to penalize the other person to deter people from acting like that in the future.
Right.
So the most common instance is drinking and driving.
Yep.
And
it's inherently reckless conduct, very dangerous, likely to hurt or injure or kill, and so the law certainly allows us to pursue punitive damages in those situations.
Sure. So the effect of that is if you have the same person, if they're in a car accident where they're injured by the little old lady that was just negligent versus a drunk driver who chose to get behind the wheel and operate the vehicle while intoxicated, the latter case is more valuable than the former case because there's an element of punitive damage to it.
Right. And not to get too far down the rabbit hole, but insurance doesn't cover punitive damages. But insurance companies, and we've talked a little bit about bad faith, in order to comply with their duty of good faith and protecting their insured, they have to consider whether or not an insured may be facing a allegation of, or the injured plaintiff's entitled to punitive damages. So, as Clint was saying, it does make the case more valuable because if we litigate that case, that is certainly something we would see for our client if our client's injured by a drunk driver.
Sure. Now, these types of damages are different than the type of damages we sometimes see in employment law cases, and I'll let Matt talk more about that and about equal pay day.
And quick interjection, you guys, you've got Paula McCord.
Okay, Paula. Yeah.
She says, "Hey guys." So
Paula, good to hear from you.
You got quite a few people watching too. Haven't said hi yet, but tuning in.
Okay.
All right, well, we just talked about equal pay day. So essentially what that means is we're 92 days into the calendar year, and the wage gap between what men earn on average and what women earn on average, it shows that women would have to work about 92 extra days in order to compensate to make the same that a man would make. So today is that 92nd day of our year, so it represents Equal Pay Day. Under Florida law and federal law, an employer cannot discriminate based on pay between a man and a woman. The types of lawsuits that we've discussed before, discrimination, things like that, similarly, you'd be able to proceed forward under those statutes, but under the Florida Equal Pay Act, as well as Florida's version of it, both of those specifically address the issue of somebody getting paid less due to their gender. Now, there are considerations companies can take into consideration, merit, seniority, skill level, things like that. But when a man and a woman perform the same duties at a job and there's none of those extra factors going each way, then they're required to make the same. And if an employer finds himself in that situation, they're not allowed to lower the man's pay to that of the woman's. They actually have to increase the woman's pay up to that of the man's in order to rectify the situation and not violate the statutes.
Makes sense. It's
Yeah.
fair.
No, it definitely is fair, and certainly I'm glad this has been brought to attention. It's obviously something that historically is persisted for way too long, and if there's women out there that feel like they're not receiving what they should from their employer and have questions for Matt, don't hesitate to call and ask him about it.
Because actually, somebody has a question here. What do they do if that's the case?
Well, obviously you're free to address it with your employer if you believe there's a pay discrepancy between an individual and another individual in the same company. But there's a lot of factors that go into it. So if you want to give us a call, I'd be happy to talk it through with anybody as far as what considerations are permissible and what kind of considerations are not permissible.
And just for viewers, for all of our cases, employment law and personal injury, there's never a cost to call us and get answers to what you should do, whether or not you have a case. And if we take your case, there's no upfront cost. You don't pay us a retainer or pay us by the hour. You hear my Alabama accent. There's no upfront cost. And so if you have a question, just call us. We can answer it. If you have a case, then we take it on a contingency fee, which means you don't pay us unless we recover for you.
Right. All right. So
okay.
with that, are there any other questions we need to address?
I don't think so. I feel like you should share with the viewers, though. We were just talking about with Megan with her accident, because so many people will probably get in car accidents and they don't know exactly what to do, like the immediate next step.
Not you, Megan.
Not me, Megan.
All right, another Megan.
Another Megan.
All right.
First is go get treatment.
Yeah,
if you have any.
Yeah, I was joking. Megan, who's behind on the other side of the iPhone, was brought up that she had a friend that was injured in a car accident and who's actually interned a little bit with this Megan. And I was joking that I don't think the Megan who got in the car accident has learned anything from these segments. But yes, if you feel right after a car accident is not the time to be, strong or courageous or something. I mean, you have every right to go look after yourself. You want to make sure that you're okay. We live in 2019. There's constant technology, objective diagnostic technology that can X-rays, MRIs, CT scans. There's all kinds of things that can be done to make sure you spend 30 minutes in an MRI machine, you know whether you have an injury or not.
Yeah.
go do it. Take advantage of it. You have personal injury protection. As long as that's going to be the law in Florida, then take advantage of it. And you have every right to do that. But yes, you have 14 days to go get treatment if it's a Florida accident. Georgia doesn't have the same rules. Alabama doesn't have the same
There's
rules.
no reason to wait
Yeah,
though. You only
but
get one life. You take care of yourself.
Yeah, so the longer you wait, you open yourself up to arguments from the insurance company. Well, if you're injured in an accident, why did it take you so long to get treatment? And the whole "I was just trying to be courageous" argument doesn't work so great.
Yeah,
So,
right. Good
so
question.
yes, Megan, go get checked out. We hope you're doing okay.
Okay.
Yeah.
Well, no other questions. Thank you guys for tuning in. Happy Tuesday, and we'll be back here next week.
Thanks.
Thanks, guys.